Right, we're going across to some news from the state of Karnataka, where the hearing in the High Court on hijab showdown is underway. The petitioner has said Karnataka order is equal to non-application of mind. The petitioner has also said not concerned with morality. High Court to decide if the Karnataka order restricts Article 25. Remember, the High Court has said, has the Karnataka order prohibited hijab is the question the court is asking right now. Nolan Pinto getting us all the developments, and also Nagarjun Dwarkanath, both of them tracking those developments from the capital city of Bengaluru. First to you, Nolan, the very latest as far as the petitioner's argument is concerned. Tell us what's really going on in court. The hearing, of course, resumed just a few minutes ago.
Well, Sneha, in fact, as of now, Senior Advocate Devdutt Kamath is making his submissions against the government order dated February 5. He says the government order is in the teeth of Article 25 and reflects total non-application of mind. These are his words. I'm quoting him. He says that the government order has two things: that wearing of the hijab is not protected by Article 25, and that they means the government, are leaving it to the CDC, that's the College Development Committee, to decide whether any exception should be made and for the hijab. He says that the declaration made by the government that wearing of headscarf is not protected by Article 25 is totally erroneous. He also says that the delegation to the CDC of these rights to whether to allow a headscarf or not is also illegal. Now, he further argues on his point. He says the only aid to the state to restrict Article 25 is when you're talking about public order. He gives an example. He says, now, public order is a state responsibility, and can a CDC consisting of an MLA, an elected representative, and a few of his subordinates decide if this exercise of right is permissible? So they've been actually discussing on these issues. He talks about Article 25. He says, as far as this case is concerned, we are not concerned with the grounds of morality or health. Only restriction which aids the state is public order. So he's gone to that issue. Now, Kamath also adds that Article 25 rights are not subjected to reasonable restrictions as under Article 19. Now, and finally, he also adds that the government order is not that innocuous. He says that prohibiting headscarf is not a violation of Article 25 and delegated to the matter of CDCs. I'm saying it is based on an erroneous understanding, he says. He actually blames the state that they have not understood this issue correctly and hence have come out with a wrong government order.
That's right. Just be with us, Nolan. We'll come back to you for more on that from the developments in court as things are progressing with the arguments being put forth by the petitioner. For a quick update from ground zero, going across straight to Nabila Jamal, tracking that story very closely. She's in Udupi, but all of this really began. Nabila, get us the mood there. Today we've seen visuals of women in a hijab being turned away, but there's been some amount of confusion really on the ground. Tell us more.
Right, in Udupi, Sneha, it seems like the situation is calm. This is exactly where the controversy sparked off, where 6 petitioners came forward saying that this is their right to wear hijab inside institutions. Now, so long that government PU college, Udupi College had set guidelines saying that no religious symbol is allowed inside, not a saffron shawl, neither a hijab. But the girls insisted, and this has snowballed to a situation where we see the Karnataka High Court taking up this case. But apart from that, we saw that many schools in Kundapura today, in fact, a few colleges did allow for girls to come with their hijab, but they were asked to enter campus with the hijab. But when they enter their classrooms, they've got to take it off. So girls have abided. In fact, this has been the norm across many schools and colleges in Karnataka, where they come inside the campus, change in the loo, take off their hijab and go inside class. While on one hand, in Kundapura itself, where the controversy sparked off, have allowed for girls with the hijab to enter, you have other districts where you saw some serious repercussions of this controversy, like in Mandya, like in Shimoga. Many institutions did not allow for students to enter wearing the hijab beyond the gate. Earlier, they were allowed inside the campus and to the loo to change and go to class, but now right at the gate, they were stopped off, saying you remove the hijab right here and come in. If not, please go home. Many parents in Shimoga, the government school in Shimoga, in the 9th standard students there were writing their preliminary examinations. They were sent back, and parents came, outrightly said that it's hijab first for us and then education. We do not want to send our girls to school if they're not allowed to wear the hijab, and they were taken back home. And that's absolutely tragic, and that's what we're seeing, hardened stance on both sides, Sneha. A very close watch on the Karnataka High Court's verdict. It's certainly going to set precedents.
Tense calm, Mustafa, as far as many districts of Karnataka is concerned, given that all, as Nabila said, will be on what the court has to say. The Supreme Court has said, we are not going to listen to this matter. There is going to be no urgent listing of this matter. It's really for the High Court to decide then. Larger bench is what both sides wanted, and they have got that. Today is going to be extremely crucial. But what about the law and order situation, especially when it comes to very unpleasant scenes, videos doing the rounds of women being turned away essentially for wearing the hijab?
Well, as of now, the Karnataka High Court has passed an interim order, and the interim order was not in favor of one party. So it is expected that the issue would still not be solved. And in fact, what we got to see is that the protest of hijab, which just took place last week, was more about on the junior college, which is the 11th and 12th standard. But while even only when the schools have started in Karnataka, we got to see that there were parents whose children were wearing hijab, and then there were some parents who didn't want their children to remove hijab even inside the classroom, and hence they had taken them back. Or we saw some visuals of in Mandya where the school authorities were stopping students who were wearing hijab right at the gate and not allowing them to enter the campus at all. So there are disturbance which is there, but as of now the law and order situation is very normal. Wherever you talk about, even when in Mandya, the visuals have come out, but there is no protest or any such thing which is taking place, and more so because of the section 144 which has been in place around the educational institution. But if you look at the issue in detail, the issue is yet to be resolved, as the final conclusion has to be reached. But yes, we have to remember that as the exams are approaching, and if these students who are wearing hijab take a stand that they will not attend classes, then their academic year can be affected. So these are things which are concerning, and even the courts understand this, and they have taken up the matter. The hearing is on. We'll have to wait and see till when the final judgment on this entire petition comes out. Only then things on a legal part will be clearer. Back to you.
Jeeb, in fact, be with us. I'll just come back to you also. Going across to Nagarjun Dwarkanath, also tracking all of those developments from the court. Nagarjun, do get us up to speed with the very latest and the set of arguments that are being put forth by the petitioner right now. And what has the court essentially said so far about Article 25? In fact, recap that for our viewers, for the benefit of our viewers who have just joined us.
Well, right now the argument is going on. Senior counsel for the petitioners, Mr. Devdutt Kamath, is arguing right now. Presently, he's quoting a Kerala High Court judgment where he says that in a judgment there was hijab allowed by the education institutions, considering it was an essential religious practice. The question right now is hijab an essential practice, and is it the right to religion? Is it compulsory to wear it? How it started was initially 1 week back when the single bench judge was hearing, they started giving quoted Quranic verses. So the bench is still hearing if hijab is still essential part of the religious practice of Islam community, and if it is so, is it a right to violation of privacy and religion according to Article 25? Can it be restricted under 19? These are the things that the court is hearing. The government side AG is yet to submit his submission right now. Still the petitioners' lawyers are giving their arguments and quoting judgments as to how hijab is essential, considered in the Muslim community, that it is quite essential as a religious practice and it is compulsory. The court is still hearing that why do you think it's a violation of Article 25 because of the government order, and the petitioners are arguing that they're quoting judgment saying why the government order saying that uniforms must be followed and no other religious attires will be allowed into the school is a clear-cut violation of Article 25. But the argument will expected to go for another hour or so till 4:30. We will hear it if the court will give another interim judgment today, or they'll take it up tomorrow too.
Absolutely. Nabila, coming to you, just take us to what really has been happening in the state of Karnataka for so many years, given that it appears that this controversy has just erupted, a month and a half ago or so. But What about what was allowed previously and what really changed for the Karnataka government's order essentially?
Right, Sneha, in Karnataka, like you see across India, you have schools having an individual arrangement with the students, particularly the Muslim girls who wear the hijab. In fact, most of the schools across Karnataka allowed for students to wear the hijab based on their equation with those students. Not many of them wore it. Remember, we are seeing exceedingly now, out of rebellion, many Muslim girls coming forward to say, now I want to wear the hijab because I've been asked not to do so. That's the kind of rebellion we're seeing, at least in the Udupi region, where many girls, earlier it was just a handful of girls who would wear the hijab to class. Now you're seeing a growing number of girls coming together in rebellion or in solidarity or whatever it is to say that their rights are violated. It is their choice. They want to wear it if and when they feel like wearing it. So earlier we saw very few children. In fact, before your first to 10th grade, hardly anybody would wear it. It's only a college level where many of the girls who really are from conservative families, those are the girls who wear it in college level. But otherwise, from 1 to 10, you hardly ever, very rarely see a girl student wearing the hijab in Karnataka educational institutions. That's a rarity. But in districts, yes, in Bengaluru, this is the norm. But in districts like, for example, in Udupi, in Mangaluru and this entire coastal region, you have very conservative Muslim families who live here who, in fact, insist that if the girl is not covering herself, then she won't even be allowed to go to school. That's how hardened they are and quite extreme, I must say. And in fact, that's the scare that we have here, that if at all these girls are not allowed with the hijab, then many of them might just drop out. But then again, it's all about discipline and uniformity. If an individual institution insists that they have a certain kind of uniformity that needs to be followed, then of course one must adhere and respect to those norms. These girls too had initially, the 6 petitioners had initially signed on an oath saying that they will follow all those, the kind of uniformity that the school has mandated. They will be strictly following it. And soon after that, about 3 months later, don't know what changed, don't know who backed them and kind of instigated them, but they came out to quote the Constitution saying, why should we be stopped? The Constitution allows us the freedom of religion and the freedom of expression. Then why must we not wear the hijab if we want to wear it? So
Be with
the
us,
norm in
Nabila. We'll just
Karnataka
come
was
back.
based on individual equation, but it now appears that
Sure.
Yeah.
Sure. Yes, Nabila, we'll just come back to you. Going across to Nolan once again for a quick update with the court talking about the fact and asking the question really about since when were these young women wearing the headscarf? Questions being raised about whether this really is intrinsic to Islam and what does the Quran really say? Nolan.
Well, in fact, before I go to that, there's an interesting argument here. I can't call it an argument as such. They are actually focusing on Article 25 when Advocate Kamath says that delegation of power to the CDC is erroneous. That is when one of the Justice Krishna Dixit observes the word. He says, law as used in Article 25 can be understood from Article 13.3, which means or mentions bylaws, notifications, etc. The observation is in context of Kamath's submission that banning of hijab can't be delegated. Kamath agrees that it includes delegated legislation which flows from primary legislation. I bound down to it. This is what he says. Now, basically, the Karnataka High Court wants to ask and wants to know from Advocate Kamath, can't legislation be delegated? Because he's been actually arguing on the fact that the CDC can't. Furthermore, as of now, the updates are Advocate Kamath is quoting from the Kerala High Court judgment saying that the court has to examine the dress code prescribed for women in Islam, and such prescription is an essential part of the religion or not. And if it forms part of essential religious practice, can it be regulated under Article 25, subsection 1? Now, in fact, he's quoting verse 31 of chapter 24. And in fact, the High Court wants to know what is kumur. And he says that it is a head cover. He explains what is it. He says it's a head cover which covers the hair on the head. And this is when the Karnataka High Court asked, does it mean hijab? And he says, yes, I'm grateful. He also says that he's citing all these verses, and there is a controversy that I want to quote what he says, that I, being a Hindu, I'm citing all these verses. I am a lawyer and assisting this court. Your lordships are right In fact, he's actually talking about how this should be reported very carefully, considering the fact that he is a Hindu and he's actually reciting these verses as of now. So these are the updates that are taking place.
Yes, Nolan, and another important update to tell our viewers, I'll just go across to Nagarjun Dwarkanath. For more on that is what the court is talking about. Questions being asked about when were they wearing the headscarf is what the High Court has asked, to which Advocate Kamath has said since the time of admission for the last 2 years until this order essentially came along is what Advocate Kamath has said. Also, another important point that Advocate Kamath is making on behalf of the girls is that students are saying, Nagarjun, they want to wear the headscarf and let it be of a matching color from the uniform, and the state essentially must facilitate the exercise of this freedom. What's wrong is the question if they want to wear a headscarf of the same color of the uniform. So in that sense, Nagarjun, uniformity will be ensured is the argument that the petitioners essentially through Advocate Kamath are making.
Absolutely true, Sneha. This is not the first time that Advocate Kamath has argued by this point. Last week also on Thursday when they argued, they said that what is uniform? Uniform has a shirt or a salwar kameez and a pant and a dupatta. So what the uniform rule says, the dupatta has to be on the shoulder, and the students are saying we are going to put it on the shoulder as well as our heads. So it will cover our head as well as shoulder. So you don't have a problem with dupatta being on the scarf, being on the shoulder, but you have a problem if the scarf moves from shoulder to the head. How does it justify is what the advocates are saying. The college uniform itself prescribes a dupatta or a scarf to be worn on the shoulders. If the same scarf, which is the same color of the uniform, if it covers the head, the college committee, the development college, the committees have a problem. Is this even valid is the question that the petitioners' lawyers are posing to the court. But however, the High Court has asked the petitioners that since how long were the students wearing the scarf or the hijab within the school campus or the classroom vicinity. The petitioners have said that in the last 2 years, all the students of this community have been wearing hijab and there was no repercussions or they were not told to be removed. Only in December it started, this whole issue started. But when I spoke to the college principal of the Udupi Government College, he specifically said that in the last 35 years, there has been no instance of any student wearing hijab in that specific college. Till the classroom entrance, they would wear it. But once they enter and sit in front of the blackboard from 9:30 to 4 p.m., every student will be in uniform. And